Good afternoon and welcome back to the second part of our webinar dedicated to the Q&A section. We will do our best to answer all the questions received. However, those which will not be answered due to time constraint will be collected and included in an updated FAQ document, which will be available on our website. As already explained by my colleagues, you can reach this page by going on Firms and follow CSP section accordingly. Now, on to the first question. Can you please confirm that arranging in terms of the FAQs requires a direct agreement between the CSP and the client for the appointment of a director? That is, if the agreement for directorship services is being entered into exclusively between the individual and the client, as opposed to the CSP, then there can never be arranging.
Basically, when we're talking about arranging, we have to keep in mind that there are various aspects that we look at. As you rightly said, if the contract is between the individual who is providing directorship services and the company, there is no arranging per se. However, from our experience, we've noted that there are some other issues that we need to take into account. Is the CSP who is, let's say, introduce the individual receiving a remuneration? Because in that case, the receipt of remuneration will be deemed as being an arranging concept. Also, we need to look into the basis of the relationship. If for any reason the client terminates the relationship with the CSP, let's say the CSP is providing services of any registered office or any other office, any other service, does that automatically mean that this director will be removed by the client? In that case, we deem the close association between the director and the company to be kind of arranging. So we understand that it's a very fine line, so we have to be careful. It's not just because the contract is with the individual that is outright not arranging.
MFSA rules state that if the director is a beneficial owner of the company as defined in PMLFTR, then this is not deemed to pass by the way of business test. MFSA guidance, however, states beneficial interest refers to rights of a beneficiary being both voting and financial, which is correct. If I hold 1% in a company of which I am a director, is this deemed not to pass the by the way of business test and thus excluded for the purposes of calculating the number of involvements?
So, originally, when we issued the rules and the exemptions regulation for consultation last December, we had included that you need to have a controlling interest. And basically, we received a lot of feedback from the industry with respect to family-owned businesses. So we have revisited, in a way, the interpretation and removed the word controlling interest, because we do understand that if you have third or fourth line generation companies, the percentage would be smaller for those family members. So you are right that we do not have a percentage, and that is why we have left it without a percentage. Because if you are providing the service to a family member, that is not deemed to be by way of business. However, your question puts a smile on my face, because you're saying 1%. And usually we've seen in the past instances where you can hold a minimal number of shares just to bypass this definition or the authorization. So we need to have our applicants and our CSPs to be transparent with us and to actually really determine whether they are doing this activity by way of business. So if we have people out there who are trying to be creative and try to start holding one share with respect to an entity, just not to be able to say that they are not doing it by way of business, and we can pick up that basically. And what I wanted to add as well is that it depends of the value of that one share, because there might be other ramifications, like you might need a how can I say an authorization in terms of, for example, the Trust and Trustees Act. So basically just holding 1% just for the sake of circumventing the authorization, is not basically acceptable.
Whilst directorship in an MFSA regulated company and/or listed company is exempt, it is still unclear whether holding a similar role in a holding company of these companies is also exempt. Likewise, would a position in a company fully owned by a listed company be exempt?
Thank you. Good afternoon, first of all. So with respect to the specific question, no, positions in the holding company of a licensed entity or in a company holding the listed entity, these directorships are not exempt from authorization. So if the service is being provided by way of business, the authorization requirement would in fact subsist.
The rules state that where an individual, CSP under threshold, does not meet its governance requirements, MFSA will require the natural person to establish a legal person. What governance requirements are we speaking about here? On what basis will the MFSA take such decision?
So what is being implied by this rule is that the MFSA will be looking at the relevant individual applicant and the level of business which he is currently carrying out. And that is part of the reason, of course, why we are, as part of this application, which has been created specifically for these type of applicants, we are requesting details about the level of business you currently have, and the jurisdictions from where the clients emanate, the type of business being offered, etc. Because we will be making an assessment, and if as an authority we deem that, for example, there is a large volume of business from which is also somewhat high risk, because possibly the jurisdictions where the clients emanate from, the type of services which are being carried out by the companies which are being created and serviced by the CSP. If we deem that an individual by himself would not have the necessary safeguards to give us the comfort that a proper service and the proper safeguards will be in place, the authority may in that case impose that the individual would need to set up a corporate to provide the necessary assurances and the necessary comfort to the authority that such level of business can in fact be handled properly.
Is an authorized CSP still deemed to be providing CSP service, RO, directorship, company secretary, if the client's company is now in dissolution?
So, we have tried to put our minds to trying to understand the question, and however, we're not sure what the question is about, and so in order not to mislead the attendee, and due to the time limits, because we could think of several options, but that would have taken all the Q and answer time, can we please ask you to reach out to the authority on the CSP regime framework queries, email, and then we will guide you accordingly. Thank you.
Thank you, Alison. Can I arrange to appoint a company secretary when the individual is an employee not directly of the CSP, but of a group company?
So the rules are very prescriptive in this regard, and basically a CSP can only arrange for an employee of that CSP. However, we received a number of queries in this regard, and we are looking at some possible solutions to extend maybe the definition to the group. However, what we are asking is that if you are in such a situation, you have such situations, to reach out to us and provide us with information about the group structure and the directors of each entity within the group, and also who this employee that you are arranging for is employed with. We will then be able to guide you accordingly.
Can an accountancy and audit firm apply for under threshold Class A CSP if it satisfies the threshold requirements? If we apply as an under threshold Class A CSP as an audit firm with a sole director MLRO, do we require to have a separate person as a compliance officer? If we as accountants lease an office or part thereof to our clients and they use it as their registered address, does this fall out of scope of the CSP rules?
So, with respect to the first part of the question, the Class A under threshold applies only to individuals and to civil partnerships. So, if the audit firm is set up as a civil partnership, then yes, there is the possibility that the audit firm can be fall under the Class A under threshold. However, as we need to specify that this applies only to individuals and civil partnerships. As for the compliance officer requirement, this will be taken on a case-by-case basis in such cases, again, because we would need to look at the level of business being undertaken by the CSP. If it is a Class A under threshold, one can assume, obviously, that there wouldn't be a large number of mandates, and even the turnover would be up to the threshold which satisfies the under threshold Class A. However, we would look again also at the business model and the risks which are being faced by the company. So there could be instances where we might require an external compliance officer. As to the last part of the question with respect to leased offices, in that case, it would depend on the agreement. So if it is purely a lease agreement and nothing else, in that case, there wouldn't be the requirements and the conditions relating to offering the registered office service. So if it's purely a lease agreement, that would not be a CSP activity, and therefore that is not part of the CSP activities which would be regulated.
If our firm is registered under the Trust and Trustees Act and hence applies for authorization as stipulated in the CSP Act, under which act will it be regulated and which licensing structure will apply?
So, if I understand this question correctly, if a company is currently already has a license to act as a trustee, so it has undergone the licensing process in terms of the Trust and Trustees Act, such companies are exempt from applying for CSP license, for CSP authorization. So they can basically offer the CSP services through the licensed entity under the Trust and Trustees Act without the need to apply for a separate authorization under the CSP Act. And in fact, the Trust and Trustees Act specifically provides that company services, in fact, are possibly the only other service other than trustee and fiduciary services which they are licensed to provide, which they can provide, because CSP services are deemed to be compatible as well with trustee services. With respect to which regulatory framework and legal framework would apply, which would apply in that case, it would be the legislation under the Trust and Trustees Act and any regulations issued thereunder which would apply, as well as the regulatory framework for trustees which would apply at that stage. In fact, we are currently in the process of reviewing the regulatory framework for trustees as well, with a possibility of aligning a lot of the requirements and a lot of the and the rules and regulatory framework in general.
The MFSA's guidance note states that where an individual acts exclusively as a director or company secretary of a company or group cause of in a family business as a consequence of a family relationship by consanguinity or affinity with the founding members, these services are not deemed to be carried out as a service to third parties. Consequently, such individual would not require authorization under the CSP Act. What degree of family relationship must exist between an individual and the founding member or members of the company or group for said individual to benefit from this exemption? Moreover, how does one determine whether an individual is a founding member?
So we had an earlier question about this, and basically I will just repeat that we did not specify a level of consanguinity and affinity for the purposes of this definition, because we understand that you cannot put a figure to that. We also, the founding member, the second question was how one does determine whether the individual is a founding member, and basically we need to go back to whoever set up the company. I mean, if the person set up the company is related to you in some way or other or form as prescribed in the rule, then that will be the founding member. I mean, that's why we didn't put the level of the degree of affinity and consanguinity, because obviously each family tree will be different, but obviously that is the intention we with respect to this definition. As I said, in case of difficulty, please do reach out, as we had several questions similar to this and queries which we have answered and requested further information, and we have satisfactorily resolved.
Where a natural person is an over-threshold Class A or B, can she be his or her own compliance officer?
No, so in these cases for Class A and Class B over threshold, the compliance officer needs to be outsourced. The decision was taken in this case because we deemed that if you fall over the threshold for Class A and Class B, there are obviously additional risks, and there's a larger business, and therefore we require that the compliance officer has basically the licensed entity, basically the licensed person, is not marking their own homework, basically. So the compliance officer, as always, needs to have this element of independence in carrying out their function.
With regards to the compliance culture, how are you seeing this being applied to individuals?
Okay, so this is an interesting question, because for me it seems to imply that there's the understanding that a compliance culture is something which should only exist in a body corporate, in a legal entity, which I don't think is the case. The compliance culture basically is how a licensed person, whether it's an individual or a corporate, basically their attitude and their approach to compliance, basically, and how compliant, how cooperative with the authority that person is. So it goes, I mean, we look at various aspects which determine whether a licensed person, and they use the term person widely, has a compliance culture or not. So basically the fact, for example, I can give an example, a practical example. We have certain license holders who for example, are always late with regulatory submissions, for example, or else we have a theory that some licensed entities do not have a reminder to submit their regulatory submissions, but they have a reminder to send us a request for an extension for the regulatory submissions. So for us, that is not a compliance culture. So that is what we expect of our, whether it's an individual or a body corporate, we expect licensed entities at the end of the day to understand that a license, an authorization is a privilege, it's not a right. So, and they need to be aware of their obligations under the various legislative and regulatory frameworks, and to ensure that they are always proactive in ensuring compliance with all these requirements.
If an individual is exempt from authorization under the CSP Act because the director roles are not listed entities supervised or licensed by the MFSA, but the individual also has one directorship role with respect to a regular trading company abroad, non-EU. Is this individual required to be authorized with MFSA with respect to this one letter role?
So, first, whether you need authorization for just one role, all depends on whether you are holding yourself out. So, if you are just providing this one role and you do not intend to increase the directorships, and you don't have CVs all over Malta trying to advertise that you are willing to act as a director, in that case, since it's just one directorship, you will not need authorization. However, as I said, if your CVs are all over Malta and everyone knows that you provide directorship services, the moment you meet someone, you tell them that you do provide this service, then obviously you will be holding yourself out and you would require authorization.
Given that the other director is the business developer, can I have the position of compliance officer, MLRO, and risk manager? This is being asked also since our company is small with 3 employees. So from a proportionality perspective, we believe that I could accommodate all 3 positions.
Okay, so first of all, I welcome the sort of the approach where you are recognizing that since a person is the business developer, so the person involved in bringing in the business to the entity, that you recognize obviously that that person cannot be the person who will carry out the compliance function, the risk function, and the MLRO function. So that is already a positive. With respect to whether the second out of 3 directors, from what I understand, director can take on all these positions, we would need to look at this again on a case-by-case basis. Reason being, because sometimes our understanding of a small entity is not everybody's understanding of a small entity. So we have had instances where, for example, certain licensed entities state, but we are a very small company. It's true, there are and we're just 3 employees for a very small business. But when we actually looked at the business of the company, the level of business was actually quite large in volume. So in that case, the business was not small. If anything, there were lack of resources for the size of the business. So we would need to look at it on a case-by-case basis. As I said, so we can't say that we'll exclude it, because there can be instances where we appreciate that it's true that the level of business is small, the level of risks undertaken are relatively low. So we could possibly accept the situation. But at the end of the day, what we are after is that the different functions are able to carry out their role properly. So it's not a question of simply, ticking a box and having a person who can fulfill all the roles. It's a question of how these roles can actually be then implemented effectively.
Do persons who are already PQ'd need to submit a new PQ for this process? Popular question.
Indeed, a very popular question, especially today in the 2 webinars. Well, as I said earlier this morning in the other webinar, if you are lucky, you have submitted your PQ recently, so you have made use of our LH portal and submitted an electronic version. Why are you lucky? Because in that way, you can just upload your PQ again and just update it and resubmit it. The answer to this question is yes, you need to submit a personal questionnaire for this application process, because the personal questionnaires are tied to the role and the industry and the type of license you will be applying for.
Exemptions apply for licensed companies and companies of the same group, which are considered to be one engagement. Will a directorship of a company holding a licensed entity also be exempt from the CSP regulation?
Okay, so with respect, we already actually answered the question along the same lines. With respect to licensed entities, the exemption does not apply to directorships of the company holding the licensed entity. There is also mention here of an exemption to directorships in the same group. To be fair, that's not an exemption, but it's a question that of the number of counting, to be fair, of the directorship. So it's not an exemption in the case of groups, but it's the case of counting how many directorships there are. But with respect to, as I said, companies holding a licensed entity, directorships in the holding company are not exempt from authorization.
This question brings us to what Angela mentioned during her presentation, some bedtime reading. Which of the rules in the rulebook apply to individuals? Some are clearly applicable only to companies.
Here I would like to start. The rule book, the way it was devised, is principle-based. So we took out, we identified those principles that need to be adopted and put them in a rule book. The rule book is applicable both to individuals and to companies. However, as an authority, we cannot give you a list which you can just tick and say, I'm an individual, I go into this class, so I am okay. The business models of the CSPs out there are all different, and the authority cannot make that assessment for you. So, as my colleague Angela said earlier, and this you need to start reading the rule book thoroughly, holistically, together with the guidance note and the FAQs, and then once you if you're an individual, for example, and it says that if you're submitting a corporate entity application form, that is clearly not applicable to you. But what we're saying is that you have to do your bedtime reading, get up to scratch with what the requirements are, see your business model, and that is a very important step. Because you know your business model, you know your client base, you know what risks you are willing to undertake, and then adopt measures, checks, balances in place to satisfy your requirements. the proportionality aspect, you have to identify how proportionate it is. The authority will look into that during our supervision, and then if we do not deem that the appropriate measures are in place from a proportionate point of view, I mean, we will allow the CSP to rectify the situation, fine-tune, because sometimes it's just a small fine-tuning that you need, and we'll take it from there. But this exercise, the authority cannot make it for you, because we are not aware of each and every business model out there.
How is an individual providing directorship services expected to implement business continuity? If a director retires or passes away, is the director simply replaced by someone else?
Okay, so business continuity, what we're expecting here when you're acting as a director is very different from when you have other corporate services. We understand that the director is appointed by the shareholders, and you cannot just appoint an alternate director. It might be expected from you, but there are situations, especially when you're a director in a large entity, that there are already the systems in place on how a director will be replaced. Here you provide the two examples: if someone retires or someone dies. So in that case, it's not expected that you actually take steps to identify another director to replace you, so if such an incident happens. But as a director, we do expect you that you reach out to the company and ensure that there are systems in place, because let's say, for an example, you are a sole director and the shareholders or no one has thought about this. So in that case, you wouldn't have thought about business continuity. So what we want is for the directors to have a think. If the structure merits to have an alternate director, speak to the shareholders, to the client, to the company, come to an agreement and have this all documented, please, because verbally we get a lot of answers, but when we speak about like something like business continuity, is expected that it is done in writing. And if the situation is adequate, and if you deem that the measures in place are adequate, then you will just document this and inform the authority when asked about business continuity. For other services, obviously, things are different. Like for a registered office, obviously it's an ongoing relationship, and you have to take into account if it's an individual providing such CSP activity, if this individual passes away, what's going to happen. So you need to have, in that case, business continuity requirements are totally different.
Does an individual also have to register as a MLRO with the FIAU?
So yes, the MLRO actually needs to register on CASPAR on the FIAU website. I'm afraid I can't provide details about the logistics about this. I'm not an expert in the area. However, I am aware definitely that the MLRO needs to register with the FIAU, on CASPAR. They have details on their website, and they have a very good website which will guide you exactly on the process. However, from an MFSA perspective, the MLRO needs to be approved by us. So obviously we will assess the MLRO's fitness and propriety. However, once that person is approved, in fact, we always issue a formal, in fact, a standard notification that the MLRO needs to perform the FIAU as well and to register on CASPAR.
Reference is made to the MFSA's guidelines to the new CSP regime application process. It is not clear whether the documents for the new CSP entity, such as the draft of M&As, etc., need to be submitted by the 16th May 2021 or by the 15th of July 2021. Reference is also made therein to Phase 1 and Phase 2. Could you explain further?
Okay, so with respect to the 16th of May deadline, that is the deadline for the application. The accompanying documents to the application need to be submitted by 15th July. On the other hand, when it comes to phase 1 and phase 2, what this is referring to, basically phase 1 is between 17th May to November, sorry, where the MFSA will be undertaking its process to either issue authorization or provisional authorization, depending on the class, of course, or else refusal. On the other hand, the second phase would be the following 12 months, where basically the MFSA will be undertaking the rest of the authorization process and collecting additional information and documents for those CSPs which would have been provisionally authorized.
May I take the opportunity here to ask you please to watch out for the email that we will be sending you after this webinar, whereby after filling in the survey that we are sending you, you will be able to access the presentation that was delivered today, and you can follow exactly what each phase is about. Please make sure that you watch out for this email today. Otherwise, contact us by Monday. Okay, on to the next question. Are exemptions cumulative? Example, exempt as a director of a multi-regulated company or and an overseas listed company.
With respect to the exemptions, there is no cap. So what we're understanding from this question is whether you can be exempt for more than one company. So if you are a director of, let's say, 7 companies that are regulated from the MFSA, and then you are also a director on a listed company, but whether it's in Malta or overseas, and if it's in overseas, it meets the criteria, basically, even in Malta. In that case, you can have as many directors as you wish, as long as they meet the criteria in the exemptions regulation.
Will the upfront capital of an individual be retained by the individual himself? How will this be confirmed to the MFSA?
Yes, so the capital has in fact to be retained by the individual himself, and as MFSA we request evidence of this, such as evidence of a bank statement, for example, that the necessary capital is deposited in a bank account and that it's basically retained in this bank account. And what is important is that this is maintained on an ongoing basis. So it's not acceptable to deposit the capital today and withdraw it the next day. So because if as part of our supervision this comes to our attention, that would be actually deemed to be in breach of the requirements of CSPs to have capital in place both at application stage but also on an ongoing basis.
What are the annual supervisory fees for each CSP class?
So the annual supervisory fees for each CSP class are the same, and it is €500 per year, irrespective of the class under which you fall as a CSP.
When a director's involvements include both regulated and unregulated companies, can you confirm whether the regulated companies can be disregarded when determining whether he is acting by way of business?
The by way of business test is the first and initial test that you have to undertake. The exemption come at the end. So the first thing that you need to determine is whether you are doing the activity by way of business. If the answer is yes, then you need authorization. So if you are if the answer is yes, and you only list and you only provide directorship services to listed or other regulated companies, and there is an exemption, then that doesn't count as an involvement. However, what we wanted to stress is that the first test is the by way of business. I also wanted to point out that when we say regulated companies, those are companies regulated by the MFSA.
How should the application be completed by an individual in those parts which do not apply for individuals?
So in that case, where you have an individual filling in the application and there are certain sections which clearly apply only to corporates or firms, in that case, these can be either left blank or marked as not applicable as relevant. Here, what I wanted to clarify a small point, which was actually a question which was raised in the previous webinar of this morning, and I wanted to provide a small clarification. There is a section in the PQs actually, rather than the application, which provides for an entity assessment. And somebody asked, in the case of an individual, how would this be completed basically? Would we be able to submit it without an entity assessment? In the previous webinar, I stated that this can be submitted without it. However, I was actually, I clarified this, I confirmed this, and I confirmed that actually the system does not allow you to submit it without an entity assessment. So what you would need to do is to actually attach a document, a blank document, where you just indicate that the entity assessment is not applicable because the PQ is with respect to an individual.
What will the annual return for individuals mentioned in the rules look like?
So at the moment, we already have an annual compliance return for individuals, because as you know, we already have individuals who are licensed to act as CSPs. So, and this is in fact, you can find it available on the MFSA website at the moment under firms and under the section regulation for CSPs, and you would find the annual compliance return there. Having said that, we are looking into revising our returns, especially for next year, because obviously we will need to update the returns also for all types of CSPs to reflect also the new requirements introduced by the rules. However, in any case, you would receive information about this later on, because for the previously exempt CSPs, especially, we obviously wanted to place our focus and the guidance, especially on the application process at this stage, because the submission of the annual return would not be until after the person is actually licensed for a number of months. So obviously you would be advised through the usual communication channels of the MFSA when there are changes to these returns.
For the purposes of Rule 3.1141, at which point in time will a CSP registered under the old Act and rules be deemed to be authorized?
So in terms of law, actually, the transitory provisions provide that upon the coming into force of the Act, which obviously was on 16th March, basically everybody who was registered as a CSP in terms of the previous CSP Act automatically became an authorized CSP. So you could say that basically all those who were previously registered are now already deemed to be authorized CSPs. However, the difference is that, and the law also provides for this, that they need to be classified into the new classes, because until this year, obviously, there were no different classes. And what we're doing in that respect is that we are communicating and we are reaching out to all CSPs and indicating the class which they will be assigned under in terms, obviously, of course, of the services which they had originally been registered to provide in terms of the previous CSP Act.
If two companies have the same UBO, do they count as two or one involvement?
In this case, they will count as two involvements unless they are part of the same group in terms of the definition which is included in the rules, which is a reflection of the Companies Act definition of groups.
What is the LH portal?
Okay, so I understand that whoever asked this question was not following Jessica's presentation because she gave a very detailed explanation and an in-depth explanation about the LH portal. So the LH portal, first of all, LH stands for license holder, and it is our online portal for all persons licensed by the MFSA. It is sort of the electronic portal and your electronic access to us, and through this portal is where you will be submitting your application form, and there are other functionalities eventually, even once you actually get a license, because you will be able to submit your regulatory submissions through the LH portal and so on. So basically, after the session, you will be obviously have the details of the presentation, and you will be able to see all the details about the LH portal there as well.
An individual holds 14 directorship positions. 10 of these posts are in license holders. These 10 positions are not considered for the purposes of the under-threshold Class B. 3 of the remaining positions are held within the same group, which therefore count as one involvement. That means that the individual only holds 2 involvements. Therefore, would the individual still be required to apply for an under-threshold Class B license?
The first assumption we're going to make with respect to this question is that these 10 entities, which are license holders, are licensed by the MFSA or count as per the exemption of the exemptions regulation. In that case, those 10 do not count with respect to the Class B under threshold involvements, which are limited to 10. As rightly said as well, 3 of the remaining 4 companies are within a group. So with respect to counting involvements, they count as 1. And that leaves 1 involvement. So basically what we're saying is that you have 2 involvements other than the licensed entity. As I said, this is based on the assumptions of these questions. In that case, since you are only providing services, let us say to 2 clients, authorization will not be required. However, that depends on whether you are holding yourself out and whether you are carrying out the activity by way of business. As I mentioned earlier, if you are advertising your services, you have CVs that people distribute that you are providing directorship services, that would mean that authorization is required.
If you are an employee of a business and you are appointed as director or company secretary within the group, do you need to apply for a CSP license?
Here it is not clear whether the directorship services are being part of CSP activity or no. So I'm going to be taking the 2 scenarios. In the scenario where there is no CSP activity, so the employer is not providing any CSP activity, but you are just acting as a director as part of your employment, no authorization is required. However, if there is CSP activity and you are employed with that same person, with the CSP, in this case, neither, that you don't need authorization.
What if the individual wanting a Class B, for example, is currently sitting as company secretary on a board of a company that has 1 or 2 outstanding fines with MBR? Will this impact the individual CSP Class B application?
Okay, so fines with the MBR will be taken into consideration as with any other information which the MFSA would have available as part of its assessment. So we look at an application holistically. So fines with the MBR will not make or break an application for an individual. But having said that, yes, they are taken into consideration. So we encourage, obviously, the individuals to definitely settle any outstanding penalties. This, in a way, ties in also with what we were discussing earlier about compliance culture, and an applicant who clearly has outstanding penalties with other authorities or other institutions would already be indicative of a possible issues in relation to compliance culture. So we encourage you, obviously, to look into this, but as I said, we look at applications holistically.
If an individual is a director in overseas companies, branches of foreign companies, how should that person's application be treated? Will that person need to do anything in particular, or will this be a normal CSP license application?
In this case, it will be a normal CSP application form because it is irrelevant into which type of company that you are acting as a director. The regulated activity is being a director, not in which type of company you are acting so.
I would like to ask, our CSP will be automatically moved under Class C. Do the senior managers of the CSP need to submit a PQ at this point in time?
Okay, so if I understand correctly, our CSP, I guess this is referring to an existing licensed CSP, and you understand that he will be placed under Class C. So the senior managers do not automatically require approval. We would generally, the directors would definitely require approval, of course. Then it depends on the role being carried out by the senior managers. So if it's in the case of an institution, perhaps, or a firm where clearly there is a hierarchy in the management system, in the governance structure, where senior managers are taking significant decisions in relation to the business, then in that case, yes, we would require a PQ submission. What we would recommend in these cases is that you reach out to us, you explain to us the roles of the senior managers, and we will determine whether these positions are require approval or otherwise.
In relation to Class Cs, will the authority be getting in touch with them to commence the application, or do we need to start the process from now?
So again, this question was not entirely clear. So if it's in relation to persons who think they will fall under Class C, but don't currently have a license, in that case, they should apply immediately to comply with the 2-month deadline within which to submit an application. As otherwise, if they are already carrying out business, after the 2 months, they will be deemed to be carrying out business without the necessary license. On the other hand, if the question is from an existing licensed CSP, in that case, we will be contacting you and we will tell you under which class you will fall as a CSP. This process should be completed possibly by the end of this week or early next week.
Does a non-executive director of a licensed entity need to be authorized?
Basically, in terms of the CSP Act, there is no distinction between an executive director or a non-executive director. So if you're a director, you need to apply and the CSP regime will apply to you.
The last question for this session. I had submitted a PQ in late January 2021, which is still being reviewed by the authority. Do I need to resubmit the original ID card and police conduct as part of my CSP PQ?
As already said previously, the PQ will need to be submitted. However, the attachments like the ID card and the police conduct, unless there is an expiry date or something of the sort, it's not necessary to resubmit them, but the PQ must be submitted.
Thank you, Jessica. Thank you, Alison. We're stopping the questions here for now. Please rest assured that we will be populating the FAQs document, which is available on our website with all the questions that we have received and did not manage to answer during this webinar. I now pass on the floor to Emily Benson.
Thank you, Romina, and thank you everyone else for today. I think that there's been a lot of useful information given to the industry today, and I hope that it's going to help you all when you're making your applications. As a result of all the questions we received, it's been very helpful to understand the issues that are facing you. And as Romina said, we will be posting responses to the questions on the website. A lot of these questions have concerned the exemptions and the by way of business guidance. And with regard to the exemptions, it's important to understand that these are very narrow and specific exemptions put there for a specific reason. So if you don't come clearly within one of them, it wouldn't be a very sensible course to try and restructure yourself. It is a much better option to apply for authorization. If you make an application for authorization and it does turn out that authorization isn't required, I can assure you that this will be dealt with very sensibly and that your fee will be refunded, etc. But if you don't apply for authorization and you are found to have needed authorization, then this will cause you difficulties. This will cause you difficulties in that we will be able to identify people out there who are trading without authorization or who should have it. We share information with other authorities and they support this initiative. And ultimately, people who are carrying on business without authorization will be closed down by us and they will have to tell their clients that they are shut down and they risk a fine and other penalties. So please do feel that you can apply for authorization with us and we will support you. And if you've made a mistake and you don't need authorization, we will also support you with that process. So we hope that this webinar has made it clear to you that it will be a straightforward process to apply for authorization, and we do hope that you will now look at the materials on the website and start to make those applications. We thank you all for attending this webinar and we thank you all for your interest in this topic, and we are committed to building a stronger and more compliant corporate service regime in Malta, and we believe that this is an important step. So thank you all.
Thank you, Emily. That brings us to the end of today's webinar. I would like to once again thank all our speakers and you as attendees for logging into this webinar today. My final thanks go to the communications and technology teams here at the MFSA who work behind the scenes to make events like this happen, webinars like this happen. Please do watch out for your inbox for that email that we will be sending shortly in order to be able to download the presentation. Have a good day and stay safe.